Good afternoon and welcome to the first in a series of webinars entitled Best Practices at Boot Camp. Today we're going to start out and in the first in our series there are 6 plans throughout this, and they are all sponsored by the North Carolina Closing Attorney Best Practices Task Force, which is a combination of the real estate section of the North Carolina Bar Association, RELANC, which is the Real Estate Lawyers Association of North Carolina, and North Carolina Land Title Association. I want to thank you for joining us for the first in this series. And some ask, why is it boot camp? Well, when the U.S. military prepares recruits to be physically and mentally tough through a training program or through a change process, commonly referred to as boot camp. As you all know, we're going through a seismic change in our industry. As most of you are all too aware, the operating of our business has never been more challenging and about to be challenged as well. And some of these things we're going to be talking about in this series will hopefully help you address those challenges and be better prepared for what comes next down the pike from either the Financial Protection Bureau and or our lenders. Now, with this, the task force put together this series, but RELANC has made it possible by paying for all the fees associated with us presenting this series. So if you are not a member of RELANC, you should check into it at relanc.com. Our series we're going to entitle Attorneys Helping Attorneys, because that's what we're about today. It's the task force or North Carolina real property attorneys providing these information series to you such that you can be better able to address your the challenges in your upcoming business. First one, today we're going to talk about escrow practices. We're going to have another one, which will be on the 28th of this month, which deals with IT security compliance, non-public personal information, and email encryption. So if you have not signed up for that, please do that. It's set for January 28th, 2015 at 2 o'clock. 2 moderators here today, myself and Elizabeth Harrison. Elizabeth graduated at the University of North Carolina and also Campbell Law School. She practices law as a sole practitioner in Raleigh and currently serves as the chair of the Real Property Section of North Carolina Bar and as the chair of our task force. She also is a member of RELANC. I'm Jonathan Biggs. I'm a graduate of Duke and Wake Forest Law School. Practiced in private practice in Durham for 22 years prior to moving to investor's title to be the Vice President for Risk Management. I also am a member of the task force and a member of RELANC. Our guest speaker today, we're very proud to have with us today Dick Reese. Dick is a graduate of Texas and began his assaults on the world in the Navy, where he was involved in combat from Vietnam to Desert Storm. Now a resident of the Tidewater area of Virginia, he is the founder and owner of Reliant Title and also of Rhino Live. Rhino Live is an escrow security program that comes in a couple of flavors, one being Rhino, one being iTrax, that is designed to facilitate early warning system for errors and also malfeasance that may happen to your trust account. A lot of things Dick will talk to us today will be centered around how to protect ourselves and our clients' funds in the trust account, and also designed to meet compliance with the Alta Best Practices, which is an oncoming lender concern, as well as the North Carolina State Bar. This time I'd like to turn it over to Dick. Dick, thank you for being with us today. And before I let Dick go, let me mention a couple of administrative things. There's a chat window on your screen, and you can send us questions that way by texting them to us, and we'll have question and answer session at the end. One thing I would like to remind you of is that this is for informational purposes only today. We wanted to get the word out and get this information in the hands of our attorneys. However, this presentation has not been approved for CLE credit, so this presentation is really for the educational purposes which it's intended. Dick? welcome and look forward to hearing from you.
Thanks, John. I really appreciate getting a chance down to Chapel Hill again. And I guess last night I got to finish one of my bucket list items and the opportunity to go to a Duke basketball game, although the outcome wasn't quite what we wanted it to be. So chin up today. Every once in a while, I got into this business back in 1998, having retired from the Navy and having grown up in real estate in Texas. And my gosh, has the world ever changed? So how do we ever get here? And I guess it all really started around 2008 when the U.S. economy crashed and there were a lot of bad mortgages out there. There were a lot of embezzlement, defalcations, and all kinds of problems. It seemed to accelerate with the near simultaneous failure of New Jersey Title and Southern Title, which is both regional title insurance agencies, one of which was located in Richmond, which is the capital of Virginia. And so along came the Consumer Financial Protection Bureau, which sprung out of the Dodd-Frank legislation in 2010. And both the CFPB and the National Association of Insurance Commissioners took a really hard look at business model, business conduct, the controls and practices that were in place in our industry. And I guess the biggest thing that everybody noticed was there were some problems with the way we handled the money. And forget who it was here at Investors that said that defalcation is the scariest word in the title industry. That came, I think, a little bit before your time, John. But that's a quote that I followed. And as an agent now, we're not only faced with being responsible to our title insurance underwriters. There has been both a Consumer Financial Protection Bureau ruling in 2012, and then the Office of the Comptroller of the Currency in 2013, who has now put the burden of oversight and responsibility on third-party vendors, which we all are as title agents or settlement attorneys. Well, that responsibility has now been squarely placed on the shoulders of the lenders. Of course, if you look at the demise of the mortgage industry, while the title industry may have been responsible for about $1 billion in defalcations, embezzlement, and theft of settlement funds over about a 3 or 4 year period, there was, somewhere between $3 to $4 trillion in bad mortgages out there. So some could argue that the fox is in the hen house, but unfortunately we're now being overlooked by the lenders and having to not only meet the standards that are imposed by our underwriters, but also the standards and regulations that are going to be imposed by the lenders. And the question is, what are they going to call for? When are they calling for it? And how are we going to comply with how many different lenders that are out there? I had the opportunity in March to attend the Mortgage Bankers Association regulatory legislative conference up in Washington, D.C., and one of the solutions that was put forward by one of the money bank lenders was, the cost of oversight and regulation of these third parties is expensive. And so one of their quick solutions was to limit the number of people that they had to monitor. So best practices is coming out as probably one of the only ways for some of the smaller law firms and title insurance companies and agencies to stay in business and to follow the American Land Titles Association best practices framework. And both John and I were participants in that best practices workforce. I also had the opportunity to testify before the National Association of Insurance Commissioners in August of 2012 when they were doing the escrow practices white paper and trying to put some controls in on market conduct. And so there are 7 pillars that are established and that we're all going to have to comply with, just as my title agency in Virginia Beach is. And of those 7, the tallest pillars probably are number 2 and number 3. And I'm going to talk primarily about number 2, but I can't solely talk about escrow without the cybersecurity and all the physical implications, because we have to also safeguard the information. And so I'm going to talk about escrow standards, escrow accounting procedures, as well as some of the cyber implications as well. So where do we sit today? We all know that Respatilla and all of those new forms and so forth are coming down the pike and are going to be in place by the 1st of August 2015. So do we have until August 2015 to be ready and prepared? And quite frankly, no. I think in a lot of cases, you need to be ready today, because there are lenders that are already out there and contacting attorneys and title agencies and sending them a letter saying, we want to know where you stand in regards to these best practices, and are you certified, and have you done all the things and jumped through all the hoops? Get ready. And it's pretty daunting. I can remember about a year and a half ago when I brought back the best practices when they first were drafted by AALTA, and I handed them to my son, who's a civil engineer and UVA graduate. Sorry. But anyway, he was overwhelmed, and his eyes just glazed over. And, how do you do this? And you got to sort of swallowing the elephant one bite at a time. And the question is, well, where do I start and how do I get started? Well, and one is just to understand what the requirements really are. Now, for escrow standards, this is the gospel. Adopt and maintain appropriate written procedures and controls over your trust accounts that allow for the electronic verification of reconciliation. The key term in that is electronic verification. Additionally, reconciliation is no longer a monthly, if we get around to it, kind of a thing. In fact, it's interesting, Connecticut, I think it was a quarterly requirement. Think what happened to the attorneys up in Connecticut. It's now a daily requirement. You're going to be required to utilize positive pay, and we'll talk about all these a little bit. Now, and also, if you're holding money in a file, you must be able to document the reason and the purpose why you're holding this money. And if you have 5-year funds here, I think. So you have to document why you're holding that money and, for achievement purposes. And you should be really trying to get rid of the money before the 5-year time frame. And then the last piece is this electronic access for underwriters. And the thing here is, electronic access is not to email them the reconciliation or to post it on your website. Electronic verification really means, can you get to the underlying data? Does the data in your bank account match the data that's in your accounting system? I have a product in the marketplace, and there's a product called Rhino or iTrax that meet those requirements because they maintain 2 separate databases. So that's the whole key. And then your underwriter has to be able to view and see and monitor those on a near real-time basis. So this whole, first of all, daily reconciliation.
But before you move on, Dick, let me interject here one thing that as he goes forward in talking about the ALTA best practices, how it compares with the requirements of North Carolina State Bar. The North Carolina State Bar requires, on our current rules, that you have a 3-way reconciliation, that is bank book to client ledger to the bank itself, once every quarter. That reconciliation is a 3-way reconciliation. ALTA's best practice requires a 3-way reconciliation monthly. Additional requirement of the North Carolina State Bar is that you have a 2-way reconciliation monthly. Now, I would suggest to you that doing the 2-way monthly and then doing the three-way quarterly, it's much more effective to have been doing the three-way monthly anyway to efficiently get to the quarterly three-way reconciliation. Additional requirements coming from the Alta Best Practice is this daily reconciliation requirement. I would suggest to you that this is not much different than what we've been doing in the past, but it has a new twist. What we've done in the past is every one of us here has sat at their computer at 4:45 on a Friday afternoon waiting for the Smith wire to appear so that you can record before the courthouse closed. The daily reconciliation is of receipts and deposits, which now we will document that process for compliance with the Alta Best Practices. However, it's not much different than making sure that the Jones money went for the Jones closing and the Smith money went for the Smith closing.
Yeah, and I use this term daily reconciliation, and quite frankly, to really fully be RESPA compliant, you really need to be doing a daily three-way reconciliation so that you can demonstrate that you haven't taken Smith's money and used it for Jones. And that's one of the things that it's a personal opinion. I think this is, if you're doing a daily reconciliation, there's no reason why you shouldn't be able to be doing a three-way reconciliation as well, just to be able to demonstrate that you aren't using Jones's money for Smith or vice versa. And so, and the other thing is to understand that one of the other real reasons for doing this daily reconciliation is that the banking regulations are different for businesses than they are for individuals. With online posting on your bank account, that constitutes notification. So if there's fraud in your account or there's some other kind of a posting error, you really only have 24 hours to notify the bank. It isn't like the old days when you got your statement on the 6th of the month and you reconciled maybe by the 15th, and then the bank would then honor the mistake. But those days are gone. So if you're not reconciling every day, every transaction, you're putting yourself potentially at risk for illegal wires or illegal ACHs and other kinds of transactions. So when we talk about daily reconciliation, what are we really talking about?
One of the questions that just came in, and I'll address this because it's on point for daily reconciliation. They're curious if they have a low volume closing practice. They have to do a daily reconciliation or simply reconciliations every time there's a transaction. I would suggest to you that it is still a daily reconciliation requirement. However, if you only have transactions, real estate transactions on 5 days of the month, that daily reconciliation will be an easy process. Those other, say 15 work days of the month.
Yeah. The other question is, what is that daily reconciliation, and how do you demonstrate that you've really done the daily reconciliation? You have a summary page that prevents documentary evidence. You know, are you on the witness stand? Can you tell me that you reconciled? Give me the reconciliation for the 5th of January 2014. Where is that copy of that registration that shows your bank statements, your book statements, your trial balances? I put it in red because I think you need the trial balances. You know, where's your list of outstanding checks and where are your outstanding deposits? Because that's what a real reconciliation is. Just to say that you do it every day or you go online and you look at things, I don't think that's going to be considered acceptable anymore. And so you got to be looking at debits. And the other thing is debits and credits that go through your bank have to match what goes through your books. And just because your bank balance and your book balance match doesn't mean that you've probably done the right thing. You know, it's the wire that came in for a closing that never occurred, and 3 days later you wire the money back out. Well, that money has to show that it come into your account and it went back out again. I mean, we had a title agency up in Virginia back when the market was booming in 2003, 2004. They were day trading so on the 2nd of the month they take out $500,000. They would deposit. They'd take the money, they day trade it, and on the 29th of the month they'd put it back. And that worked real well until the market crashed. So debits and credits have to match in the books and the banks, and some of the the red flags that their underwriters are going to be looking for are stale dated checks. So it's a check that hasn't cleared for a long time. Funds that haven't been dispersed, deposits that haven't somehow made it to the bank, and any file with a negative file balance. And those are the red flags that you need to be looking at almost on a daily basis. And so the other part is written procedures. Well, what do you got to put in the written procedures? Now, before closing, I've kind of broken them down by pre-closing, post-closing, and so forth. Pre-closing, little thing, like you don't take the file to the closing table until there's a file balance sheet that shows that the money that you're receiving and the money that you're dispersing are equal, and there's a zero file balance. And then some discussions about check endorsements and how you deposit checks and the fact, how much funds will you take in personal checks. I think the limit's $5,000 here, right? And no third-party checks. A client comes in with a check made out to them, and then they endorse over to your law firm. The rules at the bank about collected and good funds changed. And then there's this whole question about good funds and collected funds, which I want to address separately because of the legislation that's here. And, I've got some proposed legislation that we're advancing in Virginia to change the good funds law because my position is good funds aren't always good. And then your deposits, anything in transit, I think Alta says 5 days, but really if you've got a $200,000 or $300,000 check that isn't in the bank by the second day, that's a RESPA violation because you are dispersing somebody else's money. How do you handle your IRS liens? And I've learned the hard way that sometimes what the IRS tells you they want isn't necessarily what they'll accept after you've given it to them. Doing a PACER search, which is checking the bankruptcy records and doing the Patriot searches, and is that all documented? And another one that I've put in red is one that kind of hit me personally. Was we weren't a party to the transaction, but there was a seller who identity theft. And right now there's no requirement to check the seller's social security number. And the social security number that was provided wasn't the individual's. And so one of the things I would like to see also, and I've already made this recommendation to the American Land Title Association, just like you're able to do a PACER or a Patriot search online, that you ought to be able to verify a seller's social security number. Banks are able to do it. Mortgage lenders are able to do it. I'm not sure. Are attorneys allowed to do that here? Do you have the ability? I know for an employer, we're only allowed to verify our employees' social security numbers. And so I think one of the other things that needs to be done is to enable us to be able to verify the social security numbers of sellers particularly. And then independent identity, your identity, we just bought the little ultraviolet light for verifying credentials. Because getting back to the incident where we're involved, the individual that used a fraudulent identity to sell property was able to open a bank account with his stolen identities. Post-closing, I strongly recommend that afterwards, prior to recording, that you do another PACER search to make sure that the property hasn't the buyer hasn't filed for bankruptcy between the time the contract was negotiated and it was consummated. You bring down, make sure that your ledger cards and your files are all balanced. Check payees absolutely have to match what's on the HUD. You can't, if it's Mr. and Mrs. John Smith on the HUD, it's got to be Mr. and Mrs. John Smith on the check, and you can't make the check out to Mr. Smith and Mrs. Smith. And then the whole issue about who can sign check and wiring and how you handle check reissues and voids and stop payments and all of those policies and procedures have to be very carefully documented, and all of those items have to be implemented, and you also have to put together a training syllabus and have records of training. And it really, when you sit back and you go, oh my God, there's not enough time in the day to do all of this sometimes. I mean,
how often should we be training our employees? I'm a small firm. I'm a solo practitioner, and I have 4 employees. And a lot of times our training takes place just because we're all interacting with each other. And I train my employees as we go. That's traditionally how it's been done. But now with the bank requirements, I'm setting up a schedule where twice a month on Wednesdays we're going to have a training lunch. Is this what all firms need to be doing if they're not already?
Something like that, or attending some of the underwriter seminars. And there's some companies that offer some online courses too. For example, there's a group called Real Estate Data Shield for IT security. Everybody's got to have all their employees trained on IT security. So if you were to go, and there's a group called Lender Secure that we're a part of, and that's a quick and easy way to do that. And
but they need to take it one step further, though, correct, by logging what they're actually doing.
Absolutely.
Not just that you're doing it, but if we're having these Wednesday lunches, or I'm sending my employees to some sort of title insurance CLE or something like that, I need to be keeping it.
Like it's almost like you have to have. And I'm going back as an ex-Navy guy. God, and I think this is why all this is coming from other governments. You document, and then you over-document. And the greatest problem with the Navy was lack of knowledge of the reference A, or this, because everybody coming in to inspect you always knew the requirements better than you did. But you have, and so you have a training card, and each employee, these are the requirements that they have to meet for this year for this position. It's almost like not only do you have a job description, but this is the training requirements for the job, and this is what the annual requirements are. And it's kind of overwhelming when you just think for the small individual practices and even the bigger companies. I get the question all the times. I'm only small. I've got a limited budget. So how do I do this? But they've got a bigger problem in the large companies, because if they're dispersed over multiple offices, they have to make sure that everybody in every office is doing it the same way. And at that same compliance seminar that I went to, the CFPB got up and they said, well, we know that everybody at corporate headquarters will be on the mark. We're more interested in the branch office that's out in Nashville. You know what I mean? It may be all right in Raleigh, but out.
Let me add on one thing to answer your question. That is that throughout the process of the examination of the Office's best practices, developing your written procedures, it's no longer a question of whether or not we did it. It's whether or not we can prove that we did it through documentation efforts. And while we as attorneys in the state of North Carolina are certainly familiar with that when it came to the trust account, now we're going to be in a situation where we have to prove it with respect to issues regarding that are off topic for today, but regarding complaint policies, employee training, and other things such as recording times. And when our finals are the title underwriter for the issuance of the policy. Ultimately, now there's a new paper trail for many of the following issues that we're documenting in our written procedures.
And then there's another simple thing, is just your software controls. Who can go into your software and open a file? Who can, print checks? Who can void checks? There's this term, freeze files. There are some softwares that once you have dispersed the file, you can lock it so that nobody can make any other changes. So somebody can't come back in 6 months later when a check hasn't cleared and then change the payee on that check to themselves. And make sure that, and I'll share a story with you a little bit later on that really circles around just this kind of incident. And then that to be able to get into your SoftPro or whatever software you're using, that you're actually using another login that's different from the login on the computer. And that, quite frankly, that you're using an industry quality software. And I know there are some people out there that are still using QuickBooks. And you need to get off of QuickBooks because they're not compliant. They're not tied to settlement files. It's easy to make changes. There's no record of who's changed things. And so you need to look at who has the ability to open and close files, void checks, print checks in your system. And then on, the unclaimed property, LDD check, how often and when are you going to follow up? How about the money that's never left the file because it was left over? Any money that you're holding for escrow? You probably don't do any interpleading of funds. But there needs to be procedures on doing that because I've actually had to have done that. And then it's cheap and it's every November you have to file a report. So is it filed every year? I don't know what the penalties. I know in Tennessee the penalties are pretty stiff for not making the report, even if you don't have anything to report. And quite frankly, one of the first things you really need to do is to sit down and do a threat assessment of what are the greatest risks getting to your escrow account from the outside. Cyber fraud. So maybe it's where you're sending your wiring instructions, who's printing your checks or where you're getting your checks from. And then, quite frankly, looking at on the inside. How about your closers and your Wi-Fi and computers and those kinds of things? And you really need to go through and verify and validate what you got, because if you don't expect it, you can expect it. And the other little comment I make is closers, when they get angry, they don't go postal, they go escrow. One of the first law firms that we went into with Rhino in Virginia, day after we installed the system, paralegal who had been there for 15 years, left to work. And when she didn't show up the next Monday, her apartment was empty. And when we flipped the script, she'd been into them for $150,000 in the account that they were in, and they still don't know what it was in the other accounts that had been closed. I know my wife's a banker, and they make her take a 2-week vacation. Your bankers have to take 2-week vacations because you can't keep things hidden. So you really sometimes have to, and it can't happen to me, but unfortunately it often does.
Dick, let me add one thing to that, and that is that in the new paradigm, we're not just concerned with employee theft or employee errors. In the old days, we were not concerned with a hacker sitting up all night in some foreign land destined to crack into any low-hanging fruit on the internet they can find for the theft of escrow funds. Today, we have to blow up our way of thinking, start from the ground up, and examine every threat that can possibly come our way. And then nothing's bulletproof, nothing's 100% perfect. But analyze those threats and address them with mitigation efforts that are best designed within our cost structure to have the most protection possible.
One of the most simplest ones is positive pay. What's positive pay? Positive pay is a system where the bank only cashes the checks that you tell them you've written. How do I tell them how they've written? Well, you have to send them a file every day out of your software that said, this is the list of checks that I've issued today. And so when those checks are being presented for payment, they go through an extra step. And so the bank has your list of checks that you've written. Then they look at the check date, check number, and the dollar amount. And if those all match, they'll honor the check. And if they don't match, they're going to notify you that there's a potential problem, and they're going to ask you to make a decision on whether to pay that check or not pay that check. Now, there's also another feature called Payee Match. This is some of the, the larger banks, the SunTrust, the Bank of America, the Wells Fargos, where not only do they check the first three, they check the payee. And I think one of the problems, a lot of people don't like the payee match because they get a lot of false positives, as it were, because one of the things I've discovered is when the check is printed, the payee is an upper and lowercase type, and it's sometimes in Times New Roman with the little curves and wiggles. So if you're using positive pay, one of the things I highly recommend is that you go to an Arial font, all capitals, and 14 point. And so that's just for simplicity's sakes, that eliminates a lot of the misreads. And you can get with your IT support, either from your software vendor, on how you can print all of your checks in Arial 14 point. I know we use SoftPro in our company, so we had a consultant with SoftPro to do that. But look at that. But you absolutely have to use positive pay to protect against check fraud. Now, if your bank doesn't offer positive pay, there are some solutions out there like Rhino and iTrax that provide built-in positive pay for the small community banks that don't have it, or you're going to have to change to a bank.
Dick, that's what I was going to mention. For the small firm practitioners, I know when I first sort of was alerted to positive pay about a year and a half ago, I went to my bank to ask about it. Most banks, I think, do have it, but they don't promote it, is what my banker told me. Yeah. And then I found out it was going to cost a lot of money. I mean, it was going to cost per check, per deposit. But my understanding is Rhino, iTrax, and the products that are like that, I think SoftPro also has some sort of reconciliation product, but doesn't Rhino have something built into it where it's like a positive pay?
Yeah, it works just like the bank system. It's we have a list of all the checks that are presented for payment because those are updated every 10 minutes. And then every day we go into the bank and see what's been presented for payment. And if there's a non-match, you get an email every morning that says these checks haven't. And interestingly enough, about 3/4 of our clients don't use their bank's positive pay system.
Well, you still need to talk to your bank about
Absolutely.
blocking ACHs, and that there may be a cost for that, but that for the small firm, that's certainly a cost that you've got to pay. But to cover the positive pay, going the Rhino route for the smaller firm is a great way to go. I mean, you're going to either be spending the time yourself to do all the reconciliation, yep, or paying the nominal fee to have something like Rhino to handle all of that.
Yep. And the other thing, there's just so many of these little nuances that you have to. The other thing that just jumped out of my mind and that I didn't remember talking about it's wire is, this block on international wires. Now you're required to put a block in on international wires, but that's not going to protect you from your wire hackers sending the wire overseas, because they'll just send it somewhere through an intermediary bank. But you still have to, one of the other requirements is to have an international wire block, but that doesn't keep the money from going overseas. It's just like in some states, like in Texas, they require 2 signatures on a check. Well, that's not going to prevent fraud, because if I'm a fraudster, I'll sign Mickey Mouse and Donald Duck, because nobody reads check lines anymore. And so this other thing is, when we get to the North Carolina Good Funds Settlement Act, and I think John or Elizabeth can talk about what it says better, and I can't speak to the law, but there you're required to disperse collected funds, and collected funds are funds that are irrevocably credited, which means the money cannot be withdrawn or recalled from your escrow account. Well, there's a provision that says you take a cashier's check, you can take a state check, and those can be substituted for good funds. And the problem there is the bank makes those funds available to you for disbursement under the Expedited Funds Availability Act of 1987, and so you disperse them, but they are not yet collected funds because it takes a couple of days. And so then you disperse the funds, and then the check comes back. There are several states that have implemented legislation saying in Idaho, for example, you cannot take more than $1,000 in good funds or a personal check. Illinois and North Dakota, it's 50. Interestingly, North Dakota used to be 10, and the realtors complained. And then Indiana and Utah, it's $10,000. So I think that's a real problem because check fraud is a $20 billion a year. And these are just examples of some fraudulent cashier's checks, and I defy you to look at them and to tell them apart from the real thing, because printers and copiers are so good. I mean, it's sort of like the guy that was taking $1 bills and bleaching them all out and printing hundreds on them to get the right paper. That's why we got into multiple colored currency. So if you are taking cashier's checks, you probably need to be verifying the funds, particularly if it's a client that you've never dealt with before, and then be very, very leery if somebody either asks, they bring you too much money, or typically what will happen is you'll get a couple $100,000 deposit on a commercial deal, and then a day later they'll call and they say, I found another property that the deal has fallen through, and would you wire me the money back? And usually they ask for a wire overseas, and a lot of them have come from the Royal Bank of Canada on these checks, which sometimes take a little bit longer. So I'm sure that, if we were to poll the audience, there would be many of you who've experienced or heard of these things. I know in Virginia Beach in the last 2 years, there have been 3 law firms and a title company that got caught by this one. It's funny, you never hear about this because nobody talks about when they have problems. Now, after you disperse the money, you need to follow up because not only is it important to reconcile, but you have a reputational problem. You want to make sure that your mortgages and your payoffs and your recordings have gone and been, fully fulfilled. And then you got taxes and hazard insurance. And my horror story that was, about 8 or 9 years ago, we were doing final title policies, and a check for the home buyer's warranty dropped out of the folder, and it was 60 days late. Home buyer's warranty company wouldn't take the check. Well, I wound up having the privilege of becoming the home buyer's warranty company, and Murphy was alive and well, and about 90 days later, the dishwasher goes out, and the kitchen floor is ruined. So for about $2,800, I was a home buyer's warranty company. Because we were just waiting till the end of the month. And then you really ought to be looking after 30 days for anything over $1,000. Anything that potentially is going to bite you, you really need to be looking at and keeping track of. From a security standpoint, this is where we get into escrow security. Again, the administrative controls, the industry software, segregation of duties. The same person who prepares the settlement statements and closes the file shouldn't be the same one dispersing the file. And whoever is signing checks, that all has to be documented. And that person, that check signer, shouldn't have had anything to do with that transaction. Make sure you got strong passwords, dual authentication on wires, and I'll go into a little bit more deep.
Before we leave that on separation of duties, the things that Dick is talking about are definitely good practices, even best practices. One thing to distinguish there, though, is that in the Alta best practices that they're expected to be compliant with for the lender's purposes, the only separation of duties required there is the fact that the dispersing party or disbursement authority cannot be the one reconciling the account. So that if someone has the ability to sign that check, they cannot be the party reconciling that account. When it comes to separation duties for check signing and check creation, or wire initiation and wire authorization, those type of things, while they are best practices, are not technically required by Alta's best practices.
And then, escrow and cybersecurity go hand in hand. Secure email, and I'll talk a little bit about why that's so important. strong passwords, master passwords. If you really want to break passwords, you can go on the internet, password cracking, and you can buy software that'll actually crack passwords for you. That's why longer is better. You should have strong passwords, and a strong password is at least 8 characters with a capital in there, a symbol, a number, or 2 numbers, and it shouldn't be password 123. It shouldn't be your dog's name, and it really needs to be fairly complex and change frequency. And then we'll talk about internet controls, and I'll get into some of this together. Who can go on the internet, where they can browse. You let your employees go to shop at Victoria's Secret or eBay, sorry. And the firewalls and browsers, and that's some of the stuff that you're going to really hone in on it in the next seminar. That's really so important, but really does have an impact. Now, this is another story I want to talk to you a little bit about. This happened to a Virginia Beach agent a little over a year ago, and this is a perfect example of why you need to put in some administrative controls on your settlement software. The ZooSpot and the Zero Access Root Key are kind of like the bread and butter hacking software out there to get in there. The keystroke loggers get to see what you're doing. Typically, they try and steal your passwords and go online, and they weren't successful to do that. And so what this malware did, rather than get in that way, is they actually went into the settlement software, created settlement files, transferred funds between the files, and posted checks. Now, this title company was one of mine. One of the Rhino clients, and they were using Positive Pay. So all of those fraudulent checks were transmitted to the bank, which meant those fraudulent checks would have all cleared because they were in the software. And the only reason that they didn't get through was they were, their account was being reconciled every day. There was escrow analysis we're doing. There were morning reports. And so the very next day, after all this, they knew immediately that there was a problem, and they called their bank. And the initial hit was for about $300,000, and there was well over $2 million in the escrow account. And typically what the fraudsters and hackers do is they'll run the trial balloon, and if they can get a little bit get in, then they're coming back for the rest of the pickings. So we saved escrow. But on the other hand, that malware now was into their settlement software, where there were well over 10,000 settlement files with social security numbers, bank account numbers, investment account, credit card numbers. And they were supposed to report all that stuff to the FTC and report that all to your clients. I'm not going to even get involved in who the company was and what they did and what was the outfit. But so that's really why you really need to protect your settlement software, because of all that valuable data that's in there. So it's not just about getting the money out, but protecting the data. And so...
Dick, can I stop you for a minute?
Yeah.
Are you saying, like, a lot of us use SoftPro? Are
Yeah.
you saying there is a passcode? Not only can we have a passcode on our desktop to get into our desktop, but then we should also have our tech people set up some sort of passcode to get into SoftPro, period.
Yeah,
It's different.
In fact, we weren't using passwords to log into our own software account, right? SoftPro accounts either. So
Well, I don't think, that's not something until you just now have said it that I have even thought about. I mean...
Yeah, I don't work in the title company. And my son went over to my son. He said, "Hey, Matt, I don't remember using a password to log in." And he said, "Yeah, no, we don't." I said, "We are now." And it's gonna be different than you log in to get into the computer.
But who, from a practical perspective, is that something the tech person in the office should know how to do, or do people need to get in touch with their software providers to do that?
There should be in there, you know, the little op guidelines or the little user manuals, it should be in there.
Something you can do yourself.
Yeah, you can use it, you can do that yourself in a matter of a couple of minutes, and so now we went in, put username and passwords, and so now it's just another firewall, another level of defense. Had this company had that defense, maybe the malware couldn't have gotten in.
Well, one thing there too, Dick, that when we start talking about logical access for specific use, there are also best practices. If a staff person has one login into the software, a different staff person has a different login, then you're able to track who made handled the file, potentially who made the typo that caused the error. It gives you an opportunity for training as well as tracking.
Plus, the malware went into one desktop, and there were no controls, so that we're able to create a file, move money between files, delete files, void checks. They could do anything. Whereas if there had been administrative controls, they couldn't have done it all. Now, from online banking, and this is where it gets into escrow funds too, for wiring, NACHA, National Automated Clearinghouse Association, online wire payments, and FBI, obviously, you need to be wiring out of a dedicated standalone computer that's not part of your network. No Java, no Adobe, no Flash, nothing else on there, and only to be used for wiring. And malware protection, automatic updates, strong passwords, dual controls, originator and password. The little devices on the right are those little tokens. Those have been compromised. The algorithms, the formulas that you use to generate the numbers are compromised. And if you have this ZooSpot malware sitting there watching you, they call this advanced persistent threat, where they'll watch you log in and wire money, and they'll know that at 2:52 on the 14th of January, this was the number that was generated. And so over 3 or 4 times, they get that number, then they're going to know what the next number is going to be. There was an agent up in Virginia that was only using single controls, thought that token was the second protector, and it isn't. And then there were some agents out in Colorado where they were using dual controls, where some person first initiated the wire, and when the approver came in, the wire was already gone because they'd broken in. So, going the wrong way. Just quick and dirty, I don't recommend that you use Internet Explorer. It's the most utilized, it's the most vulnerable. I'd recommend either Chrome or Firefox for your online banking and wiring. I know that because of this ActiveX, that some closing packages you can only use with Internet Explorer to download the closing packages, and so you kind of have to have both. But I recommend that you look at which browsers you're using, and again, lockdown computer access. The simplest and quickest way to get yourself put out of business, I think, is the failure to use secure email, because you are quickly demonstrating to any lender when you send them back a prelim and you send it unsecured that you don't understand the rules of the game. And Sarbanes-Oxley has been around since 1999, about then. And so we've had this requirement, but nobody's ever paid any attention to it. One last story. We all know that the NSA is reading all our emails. This is a personal experience. This is a couple of pictures that were taken when I was a captain of a minesweeper. Gosh, back in 1975, and it was my sister ship had caught fire. Norwood Gay, who was the general counsel for the Attorney's Title Fund down in Florida, and are good friends and old minesweeper sailors, and we were at lunch in Oklahoma City, and I started telling him sea stories. And I told him I had these pictures. So I went up in the attic, took them out of my sea chest, took them into the office. I scanned them and emailed to him. 5 days later, they were on the internet because I was on doing a Navy kind of thing. I picked up the phone. I said, Norwood, what's going on? Send my pictures to anybody. And he said, no, what are you talking about? I said, they're all over the internet. Other than the NSA, everybody's reading email. Now, I sent that out of the title company's computer. They were reading our emails and looking at attachments. What do you think's happening right now? We've heard all the stories about getting revised wiring instructions at the last minute from the buyer, from the seller, or from, send me my proceeds to this wire. That's happening all over. My wife's a banker, and she gets this all the time. She gets emails from her clients asking for money. She had lunch one day with a woman of Greek heritage, who the next day she gets an email, says, I need $35,000 wired to Greece because my aunt is sick and we need the money. There's no way. So unless you're using secure email, and that's the quickest and easiest thing you can do, I think if you were to start today, you could have secure email in your office for very little money by the end of the week. And so for me, I think, I've only been in this business since 1998. I think I've been battered by everything, but there's nothing ever to be learned from the second kick of a mule. That's my favorite. I'm tired of getting kicked. I appreciate everybody sitting through this today, and I think we pretty much hit it right on the nail. But I turn it over to John and Elizabeth for follow-up.
Well, we do have a couple of questions that have come in during the course of our presentation, Dick, and I made some notes here, and I'm going to hit these as we go through them. Some we addressed already, and some are similar. The first one that we'll address is multiple requests for a copy of your presentation. And what we'd like to do is we'll have that presentation posted in PDF form at nclosingattorneysbestpractices.org. So you can refer to that site not only for this presentation, but for the other materials that have been developed by the task force to assist in this time of change. That again is nclosingattorneybestpractices.org. Also with that, Dick's agreed to post his white paper on 6 rules to escrow security, which we'll have there as well. I'll refer you to both of those. One person asked earlier in the presentation, tell me about PACER. What is PACER? PACER is an online portal that allows for checking the federal bankruptcy files and filings. That is, since you're not going to find that federal filing stuff at our county register of deeds or county courthouse, it's an extra place to be able to find that. And I'm also seeing from Nancy Ferguson that the white paper is already posted on the website as of now. So that's there, and the presentation will be there shortly.
And John, back to PACER, you should be able to Google it. PACER, I think it comes up as PACER court search, and they'll ask you for a credit card, which you will have to set up an account. And sometimes when you do searches, it'll look like they're billing you like 12 cents, or it's really nominal, and I've never even really seen the bill come through at my firm since I've been using it, and I've been using it for a long time.
And it is, it's where you're going to find the ultimate record on that information. One of the questions that we had when we were talking about segregation of duties, question says, I'm a sole practitioner. What does that mean for me if I cannot both sign checks and handle my own reconciliation? Well, I will tell you this, that as an attorney practicing in North Carolina for 22 years, we were not going to delegate the authority to sign checks. That was just something that in my firm we made a decision that was not going to happen because money was missing, it was our responsibility. So from that standpoint, the delegation of the other duty would be preparing the reconciliation. That is authorized by a 2008 FEO 13 to have third parties either reconcile your account, whether it could be through a process like iTrax, Rhino, or some other third-party service, or whether you in fact had an accountant do it or a bookkeeper do it. That would not eliminate the requirement that you as principal would then review that reconciliation. That's certainly still appropriate and required, but that the process of delegating the actual reconciliation is the way that you comply with that.
And to those of you who are small firms out there, I've been using the Rhino product since last April of 2013. I was very hesitant at first. I've loved it. It's been a game changer for me. Every morning when I come in, I can just pull it up on my desk and see what's going on with my trust account. So gone are the days where I'm, spending a lot of time at the end of the month or at the very first day of the next month trying to get everything reconciled. It's a daily thing that is well worth the money. And when you start talking about the money, they have scales where it's based on what you're doing each month. So it could vary, and if you go over certain thresholds, it's certain amounts. But that cost is really nominal, especially if you're paying somebody in your office to do the reconciliation. You could have that person doing something else, and it's less than half of a closing one transaction, the cost. I mean, you won't even feel it, and you'll love it.
One of the other questions, or actually a couple of the questions came in regarding encrypted email. Specifically, I address these one at a time, but is encrypted email necessary versus email that's innocuous and doesn't contain financial information? So what I would tell you there is that the standard is when it contains non-public personal information. NPI. The definition of NPI is somewhat difficult to wrap our head around because it is broader than what we would think of necessarily as a client confidence, because it is related to a financial transaction. So that if you have somebody's name and their address, both of which are available in the phone book, and you say, well, that is public record, how could that be encrypted? The answer is that once it's just those two pieces of information associated with the fact that a consumer credit transaction is involved, it becomes NPI and then requires the email to be encrypted. If I simply email Elizabeth and say, do you want to go to lunch today? That's not that's not necessary for that to be encrypted. If I email Elizabeth and said, do you want to go to lunch today and discuss the big closing on the 12th, all of a sudden I've associated a name with a consumer credit transaction, and it has become NPI, which is worthy of encryption. Another person on our questionnaires, our questions, has expressed a little frustration that the lenders have not gotten behind the encrypted email yet and have IT issues on their side where they're asking the practitioner to mail them unencrypted information such as a HUD or a prelim or something like that. And the answer to that is that there are other alternatives that you can deliver that package through encryption, or that communication through encryption, things like Dropbox, where you can encrypt it on the upload, leave it there, and allow them to pull it down. Those are extra steps. At the end of the day, what I will tell you is that because somebody in a bank's office said that they can't receive encrypted email, they may be misguided, or it may be accurate, but it will not persist long because they're the ones mandating these requirements on us. They will have to comply in their own right.
I'd like to interject there as well, John. We've had encrypted email at my small firm since October of 2013, and we certainly have felt the headaches that the person that wrote in is talking about. I would say the vast majority of small lenders across the state aren't able to receive the encrypted email, and it's almost like you're training the lender because the type of encryption that our firm has is not very difficult. You send the email and they set their own password. So the recipient receives the email, sets their own password, and then they can open everything that you send to them. However, we have numerous weekly they're saying they can't open the encrypted email, which seems crazy to us, but that's what we're encountering. So it's a process. I think everyone's going to evolve. I mean, 2 years from now, if we flash forward, I think everyone will be encrypting. I think it will be the standard really for all attorneys, not just real estate lawyers, to be encrypting their emails. If you look at what's happened to banks, getting hacked into, the federal government getting hacked into. I mean, it is going to be an ethical standard down the road that everyone needs to encrypt their emails. It's just a matter of time. But for right now, you will have to suffer a little bit. And what we've found is that we've used our fax machine a lot more in the last year and a half than I've used it probably in the past 5 years before that. And we also found out that our copy machine has a way to set a password to a PDF. So if we've been beating our head against the wall with a lender, we'll go a different route and we'll encrypt the PDF with, usually we use the zip code of the subject property. And then you hit other issues because the lenders just aren't all up to speed, Dick. I know you're seeing it on a federal, like on a high level, the lenders know, but even the local Wells Fargo people aren't really up to speed. I mean, that's just how it is at this point. But you'll send it to them and you'll put no information in the email and you'll basically say, use the zip code of the subject property, and they'll write you back in the same email and say, what is that? I mean, and then you just have to call them. And you don't want to be the offender. I mean, just this week we encrypted a HUD going out to a local lender, and then they sent it back approving it unencrypted attached. So we're in an evolution, and that's what you're going to face for a while. But what you don't want is your law firm to be the one that sent the email that got hacked and the information got out there, and then you're getting in trouble for it.
One other question we have with respect to encrypted email, or actually two more questions with respect to encrypted email. People are texting in on this asking for recommendations of providers. What I will tell you is that there are many flavors of this out there, scalable from the biggest customers of Wells Fargo down to the smallest customers of the sole practitioners in a rural county in our state. They're all over the map in terms of convenience and ease of use. What I would suggest to you is that I know our title insurance company, Investor Title Insurance Company, has a list of offered providers, as well as the other title insurance underwriters here in our state have those pages available on their website as well. Anybody that you work with there could potentially help you with that. But the ultimate resource for all of these things, closingatourneysbestpractices.org, which we're culminating all those resources together to help you with that. One person's asked here, and I see her hand up, and I'm not sure how to answer her hand up, but she's asked a question in writing, and that's so I'm going to answer the one in writing. It says, what exactly is positive pay, and is it required? Now, what I will tell you is that the Ultimate Best Practice Task Force decision about whether or not positive pay would be required was a subject of great debate. And the official language of the best practice says, if available. It's required if available. The fact of the matter is, in every market, in every county in our state, it's available. So from the standpoint of it being required, the answer is yes. Now, there are two flavors of positive pay. First is reverse positive pay, which is the flavor which Dick was talking about first, where you have the 24 hours after discovering an error or a problem in your trust account to recall that before it leaves the Fed system. That's reverse positive pay. True positive pay.
Actually, reverse positive pay, John, just to be a little more technical, is the bank is required to send you a list of all of the checks that have been presented for payment that day. Then you are required to review that list and certify it and send back to them. I approve all of these checks for payment. And then the checking is on you.
It's on you.
And that's what Rhino does. No.
No, we do the checking for you automatically.
Now, true positive pay, and when Dick was talking about the pre-authorization of the checks, where you upload a file either through your reconciliation software or through your fund production software to your bank that lists the check number, check amount, and check date, and potentially check payee depending on the service you have. This is a pre-authorization and what I refer to as whitelisting the checks in advance. It is the equivalent of your calling the bank every time you wrote a check and saying, I'm going to write this check and it's okay to cash it. It's okay to negotiate it, which is on the front end. And that is more along the lines of the preventive maintenance or preventive medicine rather than potentially the autopsy if you not review the list in sufficient time on the reverse positive pay. But that's a long answer to a short question. The answer is positive pay is effectively required in all counties in this state. One other question we have here is how and when do we get certified? I will tell you that is the $64,000 question, as the old game show went, because as a practitioner, when I hear that I might have to be examined or tested for my compliance with the best practices, I have three very efficient, short, quick questions. Who, when, and how much? Those are the questions I want answered. And I will tell you right now that there are groups at work trying to develop options, multiple options for that are scalable based on the size of your operation. There's work right now going on with the AICPA develop standards such that in the relatively short future, your accountant would be able to do that for you. And when I say your accountant, that would be somebody that you've dealt with in the past, certainly. So that's the who. You're comfortable with them and their work already. The when, well, it probably won't be April 15th, but it will be according to schedules that you've already been comfortable with and working with them. And the how much would be at hourly rates which you're already comfortable paying them. Now, this process is playing out right now. The first and threshold question that comes with that is who will have to be tested. That's where the lenders have not yet given us full guidance. From that standpoint, the lenders are trying to determine that bright line where if you don't do but so much business, we're not going to invest the expense to test you on your best practices. But if you cross that line, we're going to want some third party to check you out. That line has not yet been determined by the lenders, and I will tell you this, that 9 months ago that line was 0 closings, that they wanted everybody tested. I will tell you that line has grown every month with every delay we've had in the implementation of the best practices, full implementation by the lenders. That number is growing, so the delay is working in our favor in that regard. That does not give reason or cause to delay in becoming prepared for compliance with these best practices.
Because we are seeing already in the first month of this year, different lenders are already sending out requests. John, I know you're aware of this. I know SunTrust has already sent one out, and Bank of America Merrill Lynch, through Secure Settlements, has already sent one out to people doing their closings. And what I think is happening is they're sending it to you as you might have a closing set up in the future. So, or I'm not sure if they have any sort of approved attorney list that this is going out to, or my sense of it is if you've got something on your board coming up, you may get a hit from one of these companies where they want to vet you, where they want you to supply all the best practices information for your firm to them. So if you haven't already got it in writing, we've been talking about it for about 1.5 years now. It's time to get to brass tacks and start writing your policies. It's happening.
Next question I've got is exactly what should we be training our staff? Now, this question comes to 2 points. One is, what do you need to train your staff to do to effectively assist you in your daily practice of law? That is the first and foremost answer to that question. The second is that with respect to these best practices and the procedures and policies that you're going to need to have in place from a security standpoint, whether it be escrow security and making sure that they're trained in how to follow your procedures as well as follow your audit procedures so that errors are discovered. Every problem with the escrow is not malfeasance. The majority of them will be because somebody made a typo. But being able to find that stuff, training on those issues. The biggest area of training that's out there and available for that is the training in the area of how to deal with cyber threats. Now, coincidentally, that's going to be the subject of our next webinar on January 28th, dealing more with those IT issues. And, for example, the email encryption question that we had earlier, that'll be addressed that next webinar as well. But ultimately, you're training your staff already on a number of these things. The question is, can you prove that you trained them? And having the fact that now we're going to have written policies and procedures that you develop for your office, train to those. Train to make them good employees, safe employees, as well as low risk to you and your clients' funds in the escrow account. Here, we got a couple more questions. Dick, this one's for you. Said you noted that QuickBooks was not RESPA compliant. Could you please address that?
This is, RESPA's compliance, not the right word, but there's no historical trail. There, you can delete things from there. There's no, it's not set up for 3 ways. There's some very unique methodologies. It's not tied to your settlement file. So you cannot demonstrate that what you've got in QuickBooks is really what happened. It's some places there it's connected to, but it's not an industry standard. If you don't have the ability to put those controls in there as to who can cut the check, who can void the check, if you only got one person, maybe it'll do. But on any scalable kind of an operation, it's not. I don't recommend it.
Here's one question that's overriding, and I'm sure that's the thought of a great deal of people out there, because I've been asked this question a lot, and it's just come in over the chat window, and that is, are these real estate, are these best practices for real estate trust accounts or for all money held in trust accounts? Subsequent questions or variation of that question, is this for residential practitioners, or does it apply to commercial transactions? Now, if we back up and take a look here and think about the process, I will tell you that the community standard with which we're dealing and this paradigm shift that we're dealing with the best practices is moving quickly. It's moving faster than the ethical standards will based on promulgation by our state bar. That's not a criticism of them. It's just what's going to happen in the market's going to move faster. And I offer you this. If you think that the money held in your trust account for an estate client or for a criminal client where he's giving you the fees in advance or for any other type of client has a lower degree of protection required than the money held in your trust account for a residential real estate transaction, I would say that is misguided. That would be a tough position to take on the stand, that I did not have to protect that client as well as I had to protect client B. That'd be a problem. The second thing with respect to residential versus commercial, when we think of it this way, the lenders are requiring this because they're required of it by the CFPB on consumer transactions. That's what the CFPB is concerned with, and that's what the banks are concerned with right now. However, think about the fact that you could have a $12,000, $15,000 lot loan for a residential lot that requires all this protection. I don't think it's a very big leap of faith or leap of logic to believe that they're going to require the same protections, if not more, of that $2 to $5 million shopping center, apartment complex, office building, flex space, you name it. That's not going to escape these protections or require for the protections. And the argument there, too, would be, why is that client worthy of more protection than another client? And that's a tough line that I would not want to profess and have to defend.
Yeah, I am.
We've got about 10 minutes left, Dick, and I know you wanted to touch on Morris Hardwick. Could you share that with us?
You know, the whole question is, there's this thread that says it's the small independent practice attorney that's the one that's going to create the problems. But then you go down to Atlanta, and was it Morris Hardwick and Schneider, and then they had the Lancaster title, and this is huge law firm. I don't know, a significant percentage of the real estate transactions in the entire state of Georgia. Well, they absconded with in excess of 30, sometimes 35, $40 million. We don't know what the number is. So, you know, small damage potential, large damage potential. Then you had a title agency up in New York that was a national one, and that hit WFG pretty hard, and there's about a $40 million one. So size doesn't necessarily preclude you from doing bad things.
Well, thank you for that, Dick. And I hear some people dropping off the call, so I don't have any other questions that came in from the chat window. I will leave you with this. We thank you, Dick, for being here today and sharing your insight with us. Biz, thank you for being here to help moderate this. I'd also like to extend a thank you to the North Carolina Attorneys Best Practice Task Force for arranging these seminars, for Relink for sponsoring and funding them. And if you have not visited ncclosingattorneybestpractice.org, please do so. It's also Relink, RELANC.com for the Real Estate Lawyers Association of North Carolina. Those are great resources. If you're not a member, you should look into that. I will also, with one last bit of advertising, the next seminar will be January 28th, which is 2 weeks from today. Same bat time, same bat channel. If you haven't signed up, you will get another announcement having signed up for this one, and offer you the opportunity to register for that seminar. With that, we thank you for your time and your participation, and there is an opportunity to send questions in through the North Carolina Attorney Best Practices Task Force at that website, should you have any to come up later. Thank you all very much.
Thank you.
Thank you.